Good morning, friends. Adab, Namaskar, and Sat Sri Akal. This is my 266th video, and it will be continuing with the sale because we generally lose our cases on sale deeds were not permissible under the Grant Act 1895, Section 3 and 4. Now let's read. I just read laws earlier in one of my video. Today, now I'm going to read CLA rules in 1937. Rule 10. Maintenance of Journal Land Register. MU shall maintain the Journal Land Register prepared under Rule 3 in respect of all lands other than lands in Bazar, the management of which is entrusted to or vests in the board, and shall register all mutations in column 1 thereof, and shall there enter therein that the first Cantonment Act 1864 in its preamble speaks the measures applies primarily to the Presidency of Fort Williams in Bengal, but may be extended to other territories by their governments. Rule 1. British India notified vide number 865 dated 3rd April 1867 on page 283 of Punjab Gazette for the respective cantonments in Punjab. Now, coming back to Rule 10, cantonment may be declared a sub-district under Registration Act. Any military cantonment may be declared by the local government to be a sub-district for the purpose of 1864 to provide registration assurance. The cantonment magistrate may be declared deputy registrar, powers given under Act 35 of 1864. Now, I had read this in my video. Now, that the executive, that is the the defense state officers or the cantonment exec, would further plead that because of the Crown Grant Act or Grant Act in 1864, sale purchase was allowed within military cantonment, under which act regulation and the cantonment magistrate was given the powers of a sub-registrar for registering the same sale deeds. Residents would want to know that the executive should come clean hands to the court. All sale deeds made of these old grant revenue free since the British officer purchased this revenue free grant from the original native Indian. Now we have those sanction letters given. Those are those sanction letters which I just showed you in my earlier video. That every transfer of right or interest in land in the cantonment registered under section 54, 59, 107, 123 of the TPA Act 1882, of which information has been sent to him, that is the cantonment magistrate, under subsection 2 of section 287 of the Cantonment Act 1924, or by the board when such transfer necessitates an alteration of the entries in any of the column of the register. Now, which is this register? It is the GLR. So, we should plead to the Honorable Court to read the law under TPA Act 1882, which speaks, and the Cantonment Rules Act Chapter 3 of sales of immovable properties. What does Section 54 of TPA Act says? Sale is a transfer of ownership in exchange for a price paid for or promised or part paid and part promised. As to the limitation to the territorial operation of paragraph 2 and 3 of section 54, section 1 supra, these paragraphs extend to every cantonment under section 287 of the Cantonment Act 1924. Such transfers, in the case of tangible immovable property of the value of 100 rupees and upwards, or in the case of a reversion or other intangible thing, can be made only by a registered document. As to the limitation to the territorial operations of para 2.3 of section 54, these paras can be varied. So, delivery of intangible immovable property takes place when the seller places the buyer or such person as he directs in possession of the property. A contract for the sale of immovable property is a contract that a sale of such property shall take place on terms settled between the party. It does not of itself create any interest in or charge on such property. Now, what does section 59 say, which is mentioned in Rule 10? Mortgage, when to be by assurance, where the principal money secured is 100 rupees and upwards. A mortgage under Act 20 of 1929, other than a mortgage by deposit of title deeds, can be effectively by a registered instrument signed by the mortgager and attested by at least two witnesses. That means these bungalows were being mortgaged either and are permissible. Where the principal money secured is less than 100 rupees, a mortgage may be effected under Act 6 of 1904, Section 3. A registered instrument can be signed, attested as aforesaid. So you have to understand everything is in place. So where is the dispute that sale deeds or mortgage cannot be done of these bungalows? Now let's read section 59A, reference to mortgager and mortgagees to include person driving titles from them unless otherwise expressively provided. Reference in this chapter to mortgager and mortgagee shall be deemed to include reference to persons driving title from them respectively. So that means a mortgager can even drive title from it. Let's say if the money is not repaid, what does section 107 of the TP Act says? How leases have to be made. A lease of a immovable property from year to year or from any term exceeding 1 year or reserving a yearly rent can be made only by a registered instrument by an Act 6 of 1904. All other leases of immovable property may be made either by a registered instrument or by a oral agreement accompanied by delivery of possession. Where a lease of an immovable property is made by a registered instrument, such instrument, or where there are more instruments than one, each such instrument shall be executed by both the lessor and the lessee, provided that the state government may, the words, with the previous sanction of the Governor General in Council, omitted by an Army Order 1937 from time to time by notification in official gazettes, directs that leases of immovable property other than leases from an year to year or from any term exceeding 1 year, or reserving a yearly rent, or any class of such lease may be made by unregistered instrument or by oral agreement without delivery of possession. So this is how leases were being made. So are we trying to say prior to the 1882 Cantonment TPA Act or these CLA rules which have been mentioned, where Rule 5 has been spoken of, those leases made under 1899 and 1912 code, which section were they made? So now we will read another section, 123 of 1882 TP Act. Transfer how affected. For the purpose of making a gift of immovable property, the transfer must be effected by a registered instrument signed by or on behalf by the donor and attested by at least two witnesses. For the purpose of making a gift of movable property, the transfer may be effected either by a registered instrument signed as aforesaid or by delivery. Such delivery may be made in the same way as was goods sold may be delivered. That was is the Act 2006 section speaks of registration under 354, para 1, 2 and 3 of section 54 and section 59, 107 and 123 of the Transfers of Properties Act 1882 with respect to the transfer of property by a registered instrument shall on and from the government of this act extend to every cantonment. The registrar or sub-registrar of the district or sub-district formed for the purpose of Registration Act 1902 8, in which any cantonment is situated, shall, when any document relating to immovable property within the cantonment is registered, send for information of the registration forthwith to the chief executive officer and the defense state officer and such authority as the central government may prescribe in this behalf. So, anything left, the executive, the DO and the CO would plead that the claims of the resident could not have been mortgaged. Why? Now, this is in a classic case I will share is bungalow number 17, survey number 19 of Amritsar, Kant. The bungalow has been mortgaged and it is a grant prior to 12th August 1765. Could not have been a grant under GGO 179 of 1836 because then it would have been called a new grant. So this bungalow is registered, and now the defense state officer Jalandhar has filed a suit against them, making the owner as well as the banker a party. But unfortunately, the party and the bank is not approaching, is not willing to fight his case very properly. But I can't help it, so I'm trying to lead these evidences for people now because I know everything was written by the Britishers about these old grants. So, friends, please wake up and understand your rights. Thank you. Good day.